Thank you, ladies. We will now have our next presentation, which will be made by Mrs. Erin Hill, and it will be a Trust and Fiduciary Services case study. So I will introduce Mrs. Hill and invite her to join me on stage, please. Mrs. Erin Hill is a senior associate with McKinney, Bancroft, and Hughes. She is well-versed in banking and finance, corporate and commercial litigation, trust and private client litigation. Erin holds a Bachelor of Arts degree in Spanish Literature and Language with a minor in philosophy from Davidson College. She completed her legal studies at City University, London, where she attained her Bachelor of Laws with first-class honors in 2014. She was admitted to the Bar of England and Wales and the Bahamas in 2015. She is also a graduate of the best high school in the Bahamas, Queen's College. Please join me in welcoming Mrs. Erin Hill.
Good afternoon, everyone. My name is Erin Hill, and I am a senior associate at McKinney, Bancroft, and Hughes, and I work primarily in the trust and private client practice group. And I'm so honored to be here with you to talk about a trust and fiduciary services case study. So that we're all on the same page, before we start to talk about the case study, I really think it's important to lay the groundwork on important trust definitions. So first and foremost, let's define a trust. A trust is established by a settlor when the legal ownership of trust property is transferred to the trustee and equity compels the trustee to hold, manage, and distribute such property to or for the benefit of the beneficiaries in strict accordance with the terms of the trust and the fiduciary duties imposed upon him, so that such beneficiaries have equitable ownership therein, and any one or more of those number of beneficiaries can compel the trustee to comply with the trust, and in certain circumstances can trace and recover such trust property from third parties. Now, that's a mouthful. So let's break this down. What does that actually mean? Okay, so the first line says, a trust is established by a settlor. So, what's a settlor? So a settlor is the person that establishes the trust. In other words, it's the settlor who selects the initial trustee, establishes the terms of the trust, and typically transfers money or other property to the trustee to hold, manage, and distribute according to those terms. Fair enough. So what's a trustee? The word trustee literally means one who can be trusted. And so the settlor typically chooses a trustee in whom he has complete faith and confidence. The trustee receives legal ownership or title to trust property when the settlor creates and constitutes the trust. The trustee then holds the legal title of the trust property subject to the terms of the trust and fiduciary duties owed to the beneficiaries and the beneficiaries' equitable interest therein. Okay, so the settlor gives the title of the property to the trustee to hold to the benefit of the beneficiaries. So the beneficiaries are the persons for whose benefit the trust is created. They may be named and identified in the trust document or described by reference to a class of persons. So they may say all of the children of a certain person, for example. Let's try to bring this definition to life, okay? Raquel is a multi-billionaire.
I claim it. I claim it.
And she decides to settle a trust for her two sons. She has complete trust and confidence in me. And so she asked me to be her trustee. She then gives me $50 million, unfortunately not for myself, but to hold, manage, and distribute to her sons in accordance with the strict terms of the trust. Okay, that's straightforward enough. So let's complicate it a little bit. Sometimes you have what's known as a protector. So Professor David Hayton of the textbook Underhill and Hayton on the law relating to trust and trustees said that the control of the trustee may, under the terms of the trust, be subject to fiduciary or personal powers vested in another person who may sometimes be designated a protector. A protector is literally an added layer of protection. And this is for the settlor. And sometimes the trustee will have to liaise with the protector or get the protector's consent before they do certain matters. But it's important to note that the role of the protector is not to usurp that of the trustee. Before we go on, I think it is really important to note that a protector, while not unique to the Bahamas, is a role that's not recognized everywhere. And so the Bahamas has another advantage by saying to people who are looking to bring their trust business to the Bahamas, hey, if you want, you can have a protector. That's something that we recognize in our jurisdiction, and in other jurisdictions, they may not. So that's something that we are really proud of here in this jurisdiction. So let's tie this in with our example. Raquel has asked me to be the trustee of this $50 million trust. And she then says, you know what, I think Nakia should be the protector. Keep me on the straight and narrow. And so then I have to check with Nakia before I make certain steps, or I have to get her approval before I take certain actions. But again, her role is not to usurp my role as trustee. Some trusts also have what are known as letters of wishes. So these are informal, non-binding documents. Yes, informal, non-binding. And this is so very important, these letters of wishes, and important for trustees to know that they are non-binding. I cannot say that enough. What they're really designed to do they are to assist the trustee with their decision making. So you get a letter of wishes where the settlor really says, if it's a discretionary trust and the trustee has full discretion, but the settlor may say, look, I know you have full discretion, but this is how I wish for the trust to be administered, or this is what I would like for the funds to be used, but ultimately the decision is up to you. The letter of wishes are really meant to serve as a guide for the trustees when exercising their discretionary powers, providing insight into the settlor's intention without imposing legal obligations. So like we said, the primary purpose of this letter of wishes is to assist trustees in making decisions that align with the settlor's desires, particularly in relation to discretionary dispositions. These letters are typically confidential and are not considered trust documents. So the trustees have a discretion on whether or not to disclose these letters of wishes to the beneficiaries or not, but it is more common that trustees make the decision not to disclose them, unless there's a really compelling reason to do so. So again, let's tie this in with our earlier example. Raquel, my multi-billionaire friend, has left $50 million for her son's benefit. I'm the trustee, Nikki is the protector. Okay, so she then has in the letter of wishes her preference or her wish that the entirety of the trust fund, whatever's left, be distributed to both of her sons in the year 2050, and it should be distributed in equal 50-50 shares. Fair enough. But if in 2050, one son marries a graduate of Queen's College, but the other son does not, that son gets 75% of the trust fund, and the other will get 25%. That sounds unfair, but life is not fair. We have seen letters of wishes that to me and you sound crazy, where parents talk about if their child marries someone of a different religious background or from a different school. We've seen it happen, and that's part of the reason why these letters of wishes are typically confidential. They sometimes have information in them that are quite outlandish. And so for that reason, it's really something that the trustee keeps close to the chest and they just use as a guide. Because truthfully, the trustee may also decide that, okay, Raquel, that's a little crazy. We're not going to follow that, and we're not going to split it 75-25. So again, these letters of wishes are generally they are non-binding and generally confidential. So I'm mindful that today's topic is about a trust, but also about a fiduciary services. And so it's really important that we define a fiduciary relationship between a trustee and a beneficiary. So what does that mean? It means that the trustee has specific duties that implicitly attach to the trustee's equitable obligations. Okay, still, what does that mean? So, in particular, a trustee must act honestly and in good faith, and exercise his powers in the best interest of the beneficiaries, putting their interests first, before his own self-interest and the interest of others. He must be loyal to the beneficiaries and transparent with his dealings relating to the trust and the trust property. He must avoid conflicts of interest, so that he must not put himself in a position where his duty to the beneficiaries conflicts or may conflict with his own self-interest or his duty to others. He must keep trust property separate from his own, maintain accurate records relating to trust property, and be ready to produce accounts showing historical receipts and payments made from the trust fund. He must not profit from his position as a fiduciary unless authorized. In other words, a fiduciary must never make an undisclosed profit and is accountable to his principal for any profits acquired by him by virtue of his position. Now, that's not to say a trustee cannot charge fees, and we know in our jurisdiction that is generally the practice. Trust companies charge fees, but it's that they are authorized. They have been disclosed. It's very transparent. And finally, a trustee must avoid self-dealing. So what do I mean by self-dealing? This definition has really been established from the case of Tito and Waddell No. 2, where the scenario was really described as if a beneficiary wants to sell a piece of property, and you as trustee, you're acting on behalf of that beneficiary on that sale as the vendor. So you want to make sure that the beneficiary gets the best price. But now you again say, well, hold on, what if I buy that property? So then in your personal capacity, you don't want to pay the best price. You want to pay a cheaper price. And so you are conflicted there, and you would be self-dealing. And the case of Tito and Waddell No. 2 says a scenario like that would be voidable as of right. And so that's something that a trustee really has to work on to ensure that they do not do. So these are obviously not mutually exclusive, and there are many other examples that I can list, but in the interest of time, these are the ones that I have. And while there are so many other terms for trust law and fiduciary services that we could get into, I am mindful that the bulk of today's session is really to talk about the case study, and so I'd like to get into that. Do you want me to see if this works sitting down here? With you, you okay? Okay, so here's our case study. So before I start, this is totally made up. If it feels real to you, I don't know what to tell you. Totally made up. Joe and Jane were married and lived happily for 18 years. Joe was a very successful businessman who amassed an incredible fortune. Joe and Jane had twins, Jack and Jill. Unfortunately, Joe had an affair, and he and Jane ended up in a bitter divorce. During the divorce proceedings, Joe settled the Nursery Rhyme Trust, which was a trust governed by Bahamian law and a trust with sizable assets. The trustee was Cocomelon Bank and Trust Company in the Bahamas. Can you tell I have kids? The beneficiaries of this trust were Joe and his 2 minor children, Jack and Jill. But the trust provided that only Joe was to benefit during his lifetime, and then thereafter his children. Joe died in a mysterious jet skiing accident shortly after the trust was created, and now Jack and Jill are the only remaining beneficiaries. Jack and Jill are currently 15 years old. Joe left a letter of wishes, which outlined his wish that the trust assets only be used for the children's education and maintenance, and that he would like the entirety of the trust assets to be distributed to Jack and Jill when they turn 25. As Jack and Jill are minors, the trustees liaise with their mom, Jane, when making decisions regarding distributions. Their mother, Jane, has been requesting that the trustees provide a new car, a new house, and vacations for her and her children. The trustees have denied all 3 requests, and now Jane wants to commence proceedings against the trustee. Okay, so let's discuss this case study. So first of all, let's look at it from the position of a trust officer. If we're a trust officer or we're representing the trustee, what are some things that we should be considering? Don't all talk at once. Absolutely. The trustee has to act in the best interest of the beneficiaries. Absolutely. So she said you'd look at the maintenance provisions in the trustee to see what the trustee has to do to maintain the beneficiaries. That's absolutely right. Anybody else? Raquel?
Did you tell I was so excited?
I know. Can you tell me does this work?
Sorry. So I think some of the considerations, of course, would be we note that the twins are only 15 years of age, and that the intention of the settlor, although the letter of wishes is non-binding, the intention of the settlor was really for the preservation of the trust to ensure that there could be an outright distribution to them at the age of 25. Right. So in that regard, we want to consider, the size of the trust. Is capital preservation perhaps a consideration? Are the wishes of the mother frivolous and perhaps vexatious due to the divorce? So I think that those would be some of the preliminary, amongst many others, considerations. Yeah.
Okay, can you guys, Okay, so Raquel was saying something that you can consider as capital preservation, ensuring that you have enough capital to maintain the trust. Also, the mother's, how she's feeling, they went through a bitter divorce, and, she may be trying to get some funds for herself as well. Is that accurately summarized?
Yes, and certainly just wanting to ensure, we know that the letter of wishes is non-binding, but certainly the trustee in discharging its obligations would want to ensure that you're not making these distributions for what seem to be some frivolous expenses, vacations, for example. In exercising the discretion of the trustee, what would really be in the best interest of the beneficiaries.
Absolutely. Anything else? Okay, I'm going to tell you what I think. Oh, yes,
Yeah.
That's an absolutely spot on, gold star for you. That is absolutely correct. You really do have to look at what was the children's lifestyle before the father passed. What are they accustomed to? And we don't say in the case study, but we don't say exactly how much the trust fund has, but we do say sizable assets. So you can assume that, okay, this is a trust with some meat to it. And so if they are used to vacations, they're used to a big house, they're used to flashy cars, yeah, that's something to take into consideration, absolutely. So the first thing I think the trustee should do is the trustee needs to have a plan. So what do I mean by that? So you look at the size of the trust, you review the terms of the trust deed, you look at, you need to find out Jack and Jill's needs. Okay, so they're 15, so they're probably still in high school. Will they be going to college? If they're not going to college, what will they be doing after high school? Where will they live? Where do they live now? What about doctor's appointments? Do Jack and Jill have any illnesses or specific medical needs? The trustees will only find out this information by inquiring. So the trustee needs to try to meet with the beneficiaries and their minors, so the mother will have to come along to get concrete information on their needs. The trustee then has to balance those needs with the amount of the trust fund. If you have a trust fund of $50 million, like Raquel's sons do, then you have more money to play with. You can get a nicer house or a nicer car, but if you have a trust fund with $1 million or $2 million and you still have to educate 2 children, ensure that they have adequate housing, ensure that they have transportation, ensure that you're taking care of their medical expenses, insurance, such as that, you cannot buy them a Ferrari if they need a Ford. That's just not, it's probably not feasible. So the trustees have already refused some of the requests. So you need to look, why were those refusals made? We already talked about it. You know, the types of cars, where do they live now? Can they stay there and you just maintain that? Do they need a new house? Is the new house too far away? Is it too big? These are sort of the questions that the trustee has to ask. And that goes back again to balancing the needs of Jack and Jill with the amount of the trust fund. The trustee has to remember its fiduciary duties to the beneficiaries. So the trustees always have to act in their best interest and be loyal to the beneficiaries. And so, fine, they've made refusals, but the children need a place to live. They're going to need a way to get to school. If they're used to a certain lifestyle, wherever possible, it might be reasonable for the trustee to try to continue that. The trustee has to remember that their refusals must be reasonable, okay? And so that's why they have to remember their fiduciary duties. The trustee also ought to keep proper records. So we've already said that Jack and Jill and their mother might sue the trustee. That's a real problem for the trustee if that happens. But that means the trustee might have to stand in court and explain to a judge why they made the decision that they did and be able to back that up and be able to say this was a reasonable refusal. Finally, the trustee should...
Sorry, Erin, I think we have a question from Nakia.
Oh, sorry. Right. So the question was, what gives the wife the authority, the wife and the mother of the children, the authority to take the trustee to court? So we know from our case study, she is not a beneficiary. The beneficiaries are these 2 children. So from that standpoint, she has no standing to bring the trustees to court. But we know that the beneficiaries are minors. And so she is their legal guardian. And so if a lawsuit's going to be started by the 2 beneficiaries, I mean, there are obviously, the lawyer answer is it depends, but it's most likely that she will be representing, as their guardian because they're minors, they're only 15. But also, because of their minors, the mother's involvement is much more, and the trustee's probably a little more reserved. They're going to know the backstory that the parents were divorced. It was a very bitter divorce. The mother and the wife might be trying to get more money from the trust fund for herself. And so there are lots of things that the trustee is going to be mindful of with that mother as well.
Erin, touching on Nakia's question, if we could explore a bit further, the children in this instance are minors. They're 15 years old. But let's say that they were 20 and they didn't want to wait until the age of 25 to have the outright distribution. Do you want to touch a little on the provisions that we have, which are jurisdictional advantage in the Bahamas, where if beneficiaries do commence an action, what can happen if a beneficiary does decide to go to court to challenge certain provisions in the trust?
Yeah, so, okay, let's unpack that a little bit. So the trust, in that scenario, the beneficiaries would be 20, so they no longer need their mother to be their guardian when they're going to court. So that's good. So they're going to do this in their own right. If they are joined together and they want to go and they want the distribution now, that's the query. So what's interesting is there are other jurisdictions where you can band together if all of the beneficiaries have decided, I'm finished with this trust, I don't like this trustee, and force the trustee to give you the money. We actually have this provision in our Trustee Act that prevents that. And so where in other jurisdictions the beneficiaries can force the conclusion of a trust, if you're all named and you say, I've had enough, you can force the conclusion of a trust. We actually expressly say that you cannot do that in the Bahamas. So you'd have to go to court. Maybe the trust provisions might provide for how you can terminate the trust. And obviously, we're going to get to this when we talk about the beneficiaries. You could also look at ways to change the trustee to maybe a more friendly trustee who might take you up on your request to distribute before they turn 25. Yeah? Oh, there's a question on the end.
Testing.
Yeah, I
Testing.
can-
I can be heard? Okay. Seeing as you said that the trustee have a plan, I'm gonna assume that's a financial plan included, right? So then I'm going to guess that another consideration would have been if for some reason she does comply to the request, how would that affect the financial plan?
Repeat the question for me, sorry?
You're saying that the trustee has a plan, so I'm guessing that should have been, there's a financial plan involved, like a list of ideas that, I'm providing for them until they hit a specific age.
Right.
So I have an idea of how much should be spent on each year depending on what happens.
Right.
So I'm saying if for some reason we're considering now that the trustee does fall in and actually agree, shouldn't she consider exactly how that will impact the financial plan?
Absolutely. And one of the things, especially when you have a trust with sizable assets, typically the trust will have provision for you to hire a financial analyst, an investment manager, somebody who's going to assist you. I'm not a finance girl, so I'm going to have to hire somebody to tell me this is how you should manage this money. I'm not going to know how to do that. So if you are going to deviate from the plan now, you're going to make the distribution earlier, or you're going to give them, a more expensive home or car that they want, yeah, that's going to deviate from the plan. But that's why you should be working in tandem with your investment team, especially when you have a trust with sizable assets. But that's a great point. Anything else from the perspective of the trustee before we move on to the beneficiary?
Just to note that, of course, in addition to seeking the advice of financial advisors, trustees frequently do consult with attorneys such as Erin at McKinney, Bancroft, and other law firms to get the professional advice. So that is an expense that is borne by the trust. So as a trust officer, you're not required to take these decisions in isolation. You do have the right to reach out and seek that professional guidance, which is at the expense of the trust.
And sometimes the beneficiaries actually are happy to hear that you've done that, because then they know that, okay, somebody else agrees with this decision. You haven't made this, because you don't like our mother or you don't like us, and, personal dealings. If you've had an independent lawyer who doesn't know anybody and doesn't really care, look at this and say, no, your refusals were reasonable, and that was the right thing to do. So we at McKinney, Bancroft, and Hughes, and other law firms often do look and represent trustees to give them comfort when they are making decisions. Okay, so let's say we represent Jack and Jill, and by extension, their mother, since they're minors. What are some of the things that we should be thinking about? Raquel?
I think it's a lot of the same considerations that the trustee would have been considering before. but on the side of the beneficiary. So for example, what is the amount? What is the size of the trust fund? Are we concerned with capital preservation? What was the lifestyle, as the gentleman rightly mentioned? What is the lifestyle that the beneficiaries were previously accustomed to? What are the mothers, as a beneficiary, and I'm 50, and I would want to know the mom's motivations. Does mom have a new boyfriend and she wants to be in the south of France on holiday, or what exactly is driving, because I'm not going to want my trust fund eroded. So if you're 15, those 15-year-olds are pretty strong-willed. So as a beneficiary, you're thinking long-term, but also the concern as attorneys for beneficiaries are 15-year-olds are not everyone is mature at that age, or necessarily has a full appreciation for the risks that are involved. And so it would be good for the beneficiaries to have perhaps separate attorneys advising them, separate from the trustee, so that there's independent legal advice.
Great points. Very, very good points. Here's what I think. If I'm representing the beneficiaries or I'm a friend of the beneficiary, the first thing I'm going to find out is, what are their goals? What's the best case scenario for them? Okay, you want this house, you want this car, you want these vacations, what else? Tell me a little bit about what you need, and then tell me also what would be the worst case scenario for you. You want to get a feel for you want to holistically know about their life and about what their needs are. You're going to seek information and documentation from the trustee of the trust. Now, like we said, the letter of wishes is inherently confidential, and it's highly unlikely that they will share that. They may not even tell you that that exists, so you may not know about that at all. But it is more likely that they will share the trust deed with you. Most trust officers or trustees will share the trust deed with their beneficiaries. Okay, so now you have the trust deed. You need to review it. Look at what the maintenance provisions say. What does the trustee have to do? That I can tell them, hey, in black and white it says you have to, pay for my housing. And so you want to review that and consider that in great detail. And that also comes from hiring counsel. A good point would be for them to seek independent counsel, because while their interests are aligned right now, they might not always be. They might not always see eye to eye. You want to ask the trustee their reason for the refusal. Again, they might not tell you, and that is okay if they don't have to tell you, but they might give you some indication. They might say that house was too far away from school. That 45-minute commute is too far away from school. Find something closer. They may give you something. It may be a give and take. Again, find out the trustee's goals. Every trustee is different. They might not want to share their goals with their beneficiaries, but the only way to find that out is to ask. So the trustee might say, my goal is to manage this trust for 10 years, and then I'm going to give the balance of the trust fund to you and your sister. That might be what the beneficiaries say. And that gives the beneficiary some perspective. Because if I'm a beneficiary and I think, wow, this person is managing these funds for me until I die, or until I have children, and then they're going to manage it for my children. I mean, that just totally changes the way that you're thinking. So it's really important for the beneficiaries to try to find the trustee's goals. They might not tell you, but only one way to know. And if all else fails, you've tried your best to get along with this trustee, but they're just telling you no, and your school fees are due, and you can't get anything done, then you have to look into how do you remove a trustee. So the trustee will typically tell you what you have to do to remove a trustee. In some instances, if the trust has a protector, usually you have to get the protector's consent. In our case study here, we don't mention if there's a protector. It might say you have to get court approval, or as the beneficiaries, you might want court approval just to give you a little bit of extra comfort. But that's something else that you should consider. So that's our case study, and the final considerations that I really wanted to leave you with. Remember that the relationship between a trustee and a beneficiary is a fiduciary one. Always remember that the trustee's duty is to act in the best interest of the beneficiaries. And wherever possible, try to find common ground. It's not always going to be possible, but sometimes if you just have a conversation with the trustee, you might find that you can meet in the middle. And so unless you have any further questions, I'd like to thank you all for your time this afternoon.
Thank you very much, Erin.
You're welcome.
Do we have any final questions for Erin?
Sam? I So the question was, is there a provision in Bahamian law where if the beneficiaries took the trustees to court and the beneficiaries lost, that they would lose their entitlement? Yeah, I think it depends on the trustee. We see that most often in wills, as opposed to the typical trust structure. So, for example, in a will, you'll see where a testator will say, I have selected these are what my 4 children are getting, and you're going to be my executor, and if any one of my 4 children challenge this will, they get nothing. So we see that more often in a will, but it's entirely possible if it's drafted that way. See another question? What would have happened if the trustee passed away?
Is an individual trustee, presumably.
Yeah, I guess right. So in our scenario, this was a company, Coco Mellon Bank and Trust. And so, if your trust officer passed away, you would get another trust officer at that bank. But if you had an individual acting as the trustee, for instance, Joe Blow, because I don't put myself in these scenarios when you're passing away, but if you have Joe Blow, who is the trustee, and Joe Blow passes away, what technically happens is Joe Blow's executor will step in as the trustee, but most common, the trustee usually provides for like a backup trustee if something happens. Oh, I did, yes.
Sorry about that. I wanted to just ask about the settler. Oh, yes, thank you. I wanted to ask about the settler settling the trust for himself. How does that work? What does that look like?
Yeah, and actually that's a great question. And Raquel and I spoke about this a couple weeks ago. One of the great things about Bahamian trust law is we have what's known as reserved powers. And so a settlor can set up a trust for his own benefit. Some jurisdictions do not allow that because they'll say, is that truly a trust? Because you've set up a trust, you own the assets, then you have given the assets to a trustee, but it's for your benefit. Well, what's the point of that? So there are other jurisdictions that'll say, no, you can't do that. But one of the beautiful things about Bahamian trust law is that you are allowed to say, I'm giving my assets to a trustee to manage for my benefit. And there are a lot of reasons why a settler would do that. Sometimes there are tax advantages to doing that from wherever else they're domiciled. There are other advantages, financial planning. Sometimes if the assets are shares in a company, in a family business, there are a myriad of reasons why that would be beneficial to do.
Good afternoon.
Good afternoon.
Thank you so much for your presentation.
You're
Lucille.
welcome.
It was very, very interesting and informative. I was following some of the trends with respect to transgender rights, and I wanted to know, in your practice, have you come across any scenarios where, for example, a settler leaves assets for, let's say, my 4 sons, and one of the sons, of course, changes to a female? Is that something that you've seen in our jurisdiction? And if so, how would that scenario would have maybe been dealt with?
I've seen it only once. And it was actually very similar to what you've said. Left in black and white says left to my 4 sons, and 1 or 3 sons or something like that. But one of them is now has gone through transgender or is undergoing. And so the trustee has come to us and said, what do I do? Because in black and white, it said for my sons. And now this child is going to identify as my daughter. The child now goes by she. And so what do we do? Our advice has been, it is something that we probably will see more often.
Yeah.
Our advice has been, let's go to court and see what a judge says about it.
Yeah. No, yeah, I agree, Erin. I think, Director, one of the cases I've seen very, very recently is also on the acknowledgement of a life partner being same-sex marriages. So that is a very frequent one at the moment. And so in drafting, the deed really has to reflect if the person is recognized as a life partner in their jurisdiction of residence or domicile, because of course, in the Bahamas, as of today, we do not recognize such marriages, and that is, again, as Erin mentioned, the safest way for the trustee is to seek an order for directions from the court, which will give the trustee the additional comfort and direction on how they can act in such an instance.
And there are two other points. One is the trustee will usually tell you how to modify. So if you want to make changes to a trustee, they'll tell you what you can do, what steps you have to take if you have to modify. So that's something to look at. And also, there was a huge case in the Bahamas where a grandfather left to his two sons and then for their biological children. And then one son had adopted children. So that spurred into, well, what do these adopted children get, right? So always have to look at the trustee.
All right. Thank you very much, Erin, for that very insightful presentation. Please join me in giving her a round of applause.